Your employer wants you back at work, but you're still hurt. What should you do? You got hurt at work. You're still in pain. You may still be in treatment. But now your employer says there is a job waiting for you. Maybe they call it light duty. Maybe they say it is modified work. Maybe they say the job is easy, temporary, or within your restrictions. And now you are stuck with a difficult question. Do you go back, even though you do not feel ready? Or do you refuse and risk creating problems with your workers' compensation claim? This is one of the most stressful moments in a North Carolina workplace injury case, because it is not just about whether you want to work. Most injured workers do want to get better and return to normal life. The real question is whether the job being offered actually matches your medical restrictions, whether your doctor has released you to do that kind of work, and whether returning too soon could make your injury worse. At Kellum Law Firm, our legal team sees this kind of pressure often. An injured worker gets hurt on the job, reports the injury, starts medical treatment, and then receives a return-to-work notice before they feel physically ready. That notice may sound simple, but the consequences can be serious. If you refuse work that is considered suitable under your restrictions, the insurance company may try to reduce or stop your wage replacement benefits. But if you return to work before you are medically ready, you may risk making the injury worse. That is why you should slow down and look carefully at what is actually being offered. The first thing to check is your medical work status. Did your authorized treating physician release you to full duty? Did the doctor release you to light duty with restrictions? Or did the doctor say you are not ready to return to work at all? Those details matter. A light duty release is not the same as being fully healed. It usually means the doctor believes you can do some work, but only within specific limits. Those limits may include things like no heavy lifting, no bending, no prolonged standing, no climbing, no repetitive motion, limited hours, or other restrictions based on your injury. If your employer offers a job, that job should match the restrictions given by your doctor, not what your supervisor thinks you can do, not what the insurance company hopes you can do, not what someone at work says is basically easy. The job should fit the medical restrictions. One mistake to avoid is accepting a vague light-duty assignment without understanding what the job actually requires. If your employer says, "Just come in and we'll find something for you," that may not be enough information for you to know whether the work is safe. You need to know what tasks you will be expected to perform. Will you be standing, lifting, driving, climbing stairs, using tools, sitting for long periods, working a full shift, doing work that aggravates the same body part that was injured? Those details matter because the wrong assignment can place you in an impossible position. If you try to do the work and cannot physically handle it, the employer may claim you are refusing to cooperate. If you push through the pain and get worse, your recovery may be set back. And if you leave without clearly documenting what happened, the insurance company may use that against you later. Another mistake is ignoring new or worsening symptoms after returning to work. If your pain increases, if swelling gets worse, if numbness appears, if your mobility decreases, or if the work is clearly aggravating the injury, report it. Tell your medical provider. Tell your employer. Keep records. Do not just suffer through it and hope it will get better. In a workers' compensation case, documentation matters. That does not mean you should refuse every light-duty job. Sometimes returning to modified work is appropriate. Sometimes it helps the injured worker stay active, keep income coming in, and gradually transition back to normal duties. But the return to work should match the medical reality. It should not be based on pressure, fear, or a vague promise that the job will be easy. You should also be careful about conversations with the insurance adjuster. The adjuster may ask whether you are willing to return to work. They may ask why you have concerns. They may ask whether you are refusing the job. How you answer those questions can matter. If you are worried the job does not fit your restrictions, say that clearly. If you need the job description reviewed by your doctor, say that. If you tried the job and your symptoms got worse, document what happened. The issue is not whether you are lazy or unwilling to work. The issue is whether the job is medically appropriate after a workplace injury. That is a very different question. If your employer wants you back at work, but you are still hurt, here are the basic things to think about. Look at your written work restrictions. Ask what the light-duty job actually requires. Do not rely only on verbal promises. Tell your doctor what the employer is asking you to do. Report any work activity that increases your symptoms. Keep copies of work notes, restrictions, messages, and return-to-work paperwork. And before refusing work, walking off the job, signing forms, or making statements to the insurance company, consider getting legal guidance. A workplace injury claim can become much more complicated once return-to-work issues begin. This is often where disputes start. The employer says suitable work was offered. The injured worker says the job was too painful or did not match the restrictions. The insurance company says benefits should stop. And suddenly, the injured worker is caught between medical recovery, financial pressure, and fear of losing the claim. You do not have to figure that out alone. Kellum Law Firm helps injured workers in North Carolina understand their options after workplace injuries, including disputes over light duty, return-to-work pressure, medical restrictions, and workers' compensation benefits. If you were hurt at work and your employer is pressuring you to return before you feel ready, do not guess your way through the process. Before you refuse the job, accept the assignment, give a recorded statement, or assume you have no choice. Talk with someone who understands North Carolina workplace injury claims. Contact Kellum Law Firm for a free case review. We're with you all the way.